that occurred at the Utumishi Girls Academy on the night of the 27th, the 28th of May, 2026. That resulted in the unfortunate loss of 16 students.
Go on.
Your Honor, our grounds in support of the application are that the investigators are currently waiting for critical, forensic, technical and structural reports from various government agencies and therefore we require time to receive these reports and analyze them. Secondly, Your Honor, following this incident, the school was closed indefinitely and the students released to their parents. Meaning therefore that potential key witnesses in the matter are now located in diverse parts of the Republic, requiring now time for the investigators to trace them for purposes of recording their statements. Thirdly, Your Honor, preliminary investigations have demonstrated a likelihood of interference.
Demonstrated?
A likelihood of interference with the ongoing investigations by the respondents
Yes.
Fourthly, the respondents are facing serious offenses and the incident, Your Honor, has elicited public outrage, thus placing the safety and the lives of the respondents in imminent danger.
Placing the safety and
Placing the safety of the respondents, safety and lives of the respondents in imminent danger is released on bail or bond. Your Honor, the prosecution is alive to the provisions of Article 53F of the Constitution that provides that a child should not be detained except as a measure of last resort. Similarly, the Children's Act provides for consideration interest of the child. However, Your Honor, we submit that the principle must be interpreted on a case-by-case basis. And in this instance, the safety and security of the respondents is key, especially after the release of the CCTV footage.
The safety and?
Security of the respondents. Especially after the release of the CCTV footage of the incident going viral. For those reasons, Your Honor, I pray that this Honorable Court finds that the reasons we have advanced are compelling enough to warrant the detention of the respondents for a period of 30 days at the Nakuru Children's Remand Home for their own safety and security, and also to enable the investigators finalize on their investigation. We also believe.
1 second. You also believe?
That it is in the interest of justice and within your discretion, Your Honor, to grant the orders that we have set.
Yes, Rosire, anyone else? No, this one is for lawyers. Yes. So, you want me to hear Mr. Wairegi first? Or, yes.
We equally are in support of the application. Dated the 2nd day of June 2026. And in considering this application, and based on the Victims Protection Act, and more specifically, sections 4, 9, and 10. Urge the Honorable Court to take into account the magnitude, the nature of the offense, and the public outbreak. In balancing the rights of the suspects before you, as against those who are not able to appear before you, we urge the court necessity for adequate investigations to be completed. And the request before you is one, that we find it necessary and just in the circumstances. And lastly, Your Honor, wish to highlight the prejudice. The prejudice that may be occasioned on the part of the victims of their families if the request is disallowed. This is a matter that needs closure. And it can only be obtained if the wheels of justice are allowed to take their natural course of action. Permit the investigators to complete the investigations. Obtain any necessary information that may be required. It is not a request that prejudices the suspect before you, but in disallowing the application, it prejudice to the victims and the families. So we urge you to allow the application until the second day of July 2026.
The submissions of my colleagues in the prosecution and my counterpart for the victim. Your Honor, we pray that you are guided by the provisions of Article 27, Article 28, and Article 50. of the Constitution.
Repeat the articles again. 27?
Article 27, 28, and 50. The Constitution of Kenya 2010. Which upholds, or rather provides for the upholding of the dignity of the victim. Your Honor, the application before you is basically one that, if allowed, will not only uphold the dignity of the victims, but also be indicative of justice for the victims of the incident that is the subject of this application. Your Honor, as we support the prayer for the granting of the 30 days hold, we also pray, Your Honor, that the victims, through their families, be made part of this investigation, such that every report, every action that is taken within this period that the court might grant be also made known to the victims. With that, Your Honor,
With and you?
Thank you. My name is Naivasha.
So, it's my first time seeing you. So let me remind myself of the name Mogire Hezron.
Yes, that's correct. I appear for the first, second, third, fifth, sixth, seventh.
I appear for first, second, third, fifth, sixth, and seventh respondents.
Yes.
Yes.
One of the seen the application dated 2nd of June 2026. And the starting point is that that application is closed. I demonstrate why we post that application.
Yes.
One of the beginning point is that 53F Constitution.
Order, Article 53.
53F of the Constitution, as read with Section 223 of the Children's Act 2023.
Section 2.
223. 223. One of those two provisions of the law do not require pre-trial detention of minors. And when I read this application, it is actually ridiculous because the prosecution is trying to ask you to violate those two particular provisions of the law. So as a starting point, this application does not disclose any compelling reasons.
So that you are saying, as a starting point, it is ridiculous the prosecution is asking the court to violate?
To violate Article 53F and Section 223 of the Children's Act. They are simply looking for pretrial detention without any charges being preferred against the minors. Your Honor, there are no compelling reasons
Yes.
There are no compelling reasons which have been advanced why the minors should actually be detained. And I'll demonstrate each. So, number one, Your Honor, as you read this entire application, there is no allegation that minors are at flight risk. So at least that is ruled out. Number two, Your Honor, the prosecution says that the deponent of the affidavit, says that various government agencies are involved in the investigation, and the process may take some time to complete. That's paragraph 5 of the supporting affidavit to that application. Now, Your Honor, the question you ask yourself at that point, if you release these minors, are they going to interfere with government agencies not to conduct investigation? And the answer is no. One of the potential witnesses in this particular matter, they could be adults, either teachers or whatever. Are they saying that these minors are going to exercise and do influence against those potential witnesses so as to interfere with the investigation? And the answer is no. Number three, Your Honor, the application and the prosecution have indicated indicated correctly that the school is closed indefinitely. And the students were released to their parents. Utumishi is a school in Kenya with children from all over the country. Now, does the prosecution try to tell you that these children, if you release them, they are going to those separate homes, look for the other children, convince them not to come and testify against them? It's ridiculous.
Sorry, repeat that.
The school has been closed.
The children can come from all over the country.
Yes. Now, it's not possible for these minors, they lack the resources, they lack the means, to be able to go around the entire country.
When you say the children, you mean the respondents?
Yes, that's what I mean.
So it's not possible for the respondents
Yes.
to have the means
Both financial and other means,
to reach.
go around the country, look for potential witnesses, either from the student population or parent population, and convince them or interfere with the investigation within them. It's not practical. Another reason in that application is that the matter elicited public outrage. And Your Honor, you'll allow me to draw an analogy. The last time history teaches us that public outrage was used in a trial of Jesus of Nazareth, the trial was unfair. Because Your Honor, what Pontius Pilate did, he saw his innocence, but nonetheless he washed his hands and said, "It's the one you want to use in our party. Take it." It shows how fair it was. Therefore, Your Honor, public outrage cannot be a reason to violate the minor's rights. Your Honor, closely related to that is that because of that public outrage, they say that the safety of the person, of the respondents, is in imminent danger. Your Honor, nothing can be further from the truth. Even the court as we speak today has not looked at the man, does not know who the respondents are. The police did a fantabulous job together with the children's department. The identities are not disclosed to the public. So how is the identity becoming an issue that now if they are released, their safety to their person will be prejudiced? You know, that's a red herring to ensure that these minors' rights are actually violated. And Your Honor, we ask the court to sieve out that needle of truth from this haystack of lies and obfuscation contained in this application together with the court and the Your Honor, the likelihood likelihood of interference in any investigation has not been disclosed whatsoever. These minors equally required to continue with education. They have a right to education. And when the prosecution asked for 30 days, surely we are not in a banana republic. There is the rule of law. The best interest of the child does not require any such pre-trial detention. These children are not in a common place, even the other learners, whom the respondents can go and tell that now let us intervene in the investigation of this matter. It's not possible. It is some kind of warped reasoning to violate the rights of these minors. And Your Honor, with those submissions, we oppose the application and pray that you grant the release of this particular minors. Thank you.
How do you...
Tunaenda